important, it is all India services. Malas, this is a little important. All India services includes the basic large service, of course, IAS, etc., and AGMUT. Whereas with deepest respect, the government of India, in trying to defend this case willy-nilly on any ground, is killing the AGMUT cadre. The AGMUT cadre cannot exist if this argument is correct. Now read 312. Notwithstanding anything in chapter 6, if the Council of States is declared by resolution supported not less than 2/3, it necessarily to expel national parliament.
After Goa becomes a state, now it's clearly the AGMUT cadre covers a state as well as the union territories. Likewise, Mizoram is also a state.
That's right. That's right.
Tripura also.
That they've created, they especially applied that cadre to that. But today, Malas, in fact, need not read it, just see two words, Malas. 3121 is one or more all India services, fourth line. That line alone has to be underlined. In 3121, one or more all India services. And then, Malas, subject to regulate recruitment conditions of service. Then, Malas, number 2, clause 2 talks of IAS and IPS. Let's leave judicial service in number 3, Malas. And 4. 3 and 4 are judicial service. I hope I'm clear. Now come to Prem Kumar Jain. I'm sorry, to complete. See 309 also. 309 actually is more in my favor because it is subject to this constitution, which means it is subject to 239 AA also. 309 opens with the words subject to the entire constitution. Therefore, subject to 239 AA also. In the same chapter, same part, 3 clauses apart. Then read Prem Kumar Jain with me. Subject to the provisions of this constitution, acts of appropriate legislation may regulate the recruitment and condition of service of persons appointed to public services and posts in connection with the affairs. Provided, the proviso is important for my purposes, last 4 lines of the proviso, where I'll read the whole slowly. Provided that it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affairs of the union, and for the governor of a state or such person as he may direct in the case of services and posts in connection with the affairs of the state, to make rules regulating the recruitment and the conditions of service of persons appointed. Now mark these words. To such services and posts until provision is made in that behalf by an appropriate legislature. It's a transitional temporary provision. Until provision is made in that behalf by an act of the appropriate legislature and any rules.
Executive legislation.
I beg pardon?
Executive legislation.
Yeah. Executive. Yes, please. Now, nobody is saying that if you choose to act and make a law, you can't do it under entry 41. Question is, having not done it, you are saying the appropriate legislature, Delhi can't do it. Because I apply the entire constitution without an exclusionary article to all the entries of list 2, but I exclude entry 41 by implication. Malas, this is, and remember, Malas, I mean, the impugned notification is not a statutory, not a constitutional, it's an executive rewrite, adding a 4th clause to 1, 2 and 18. Malas, your lordships have to face that point, Malas. You've got 1, 2 and 18 the constitution gave you, and by an executive impugned order, 2015, you are adding 41 to 1, 2 and 18. Malas, your lordships, with great respect, no canon of interpretation is told to your lordships. Same chapter, Prem Kumar Jain, 3 sections apart will not apply. Now turn to Prem Kumar Jain. Yes. 52. Bookmark 52, page, I'll use yours. Just see para 2, 7 and 8 I read. I'll not read again. Mr. Jain read it also. Exactly the same point Delhi High Court held and reversed by Supreme Court. The state here, or the UT here was Himachal and Delhi. Where is it here? Here, Malas, Delhi and Himachal, joint cadre was involved. A new cadre of service, may I read, Malas, very quickly? 4 learned judges, and Malas, with respect, Mr. Jain may have dealt with it later. It doesn't find mention in Mr. Mehta's submissions. Neither 52 pages nor 90 pages earlier. A new cadre of the service was constituted for the Union Territory of Delhi and Himachal, and recruitment to that cadre was made directly without complying with the requirement of Rule 4.1 of the IAS rules, etc. I'll skip this.
I read it. Madam.
No,
It's
that's all
part
right.
of
I'll-
my volume, and I read it today also.
That's all right. I'm just saying it's not part of your submissions. Also-
Submissions. Madam, I read it. It's part of my
Anyway,
today's
that
submission.
doesn't matter.
And
Now
I
been gone into.
annexed it and read it. Madam,
Then-
already reference.
Read from us fourth line. The rules were amended on December 21 by providing for a joint cadre in relation to the UTs and the Northeast Frontier Agency, and the central government formulated the aforesaid scheme to extend the Delhi Himachal cadre to all UTs by absorbing the officers of that cadre and by appointing it to officers of the Indian Frontier Administrative Service and all the union territories. The joint cadre for all UTs was brought into existence in 1968 January. Hereinafter referred to, skip that. The petitioners in the High Court challenged the creation of the new joint cadre for all the UTs and the appointment of some of the respondents thereto. It was urged in the High Court that the constitution of the new joint cadre was illegal as it was contrary to the provisions of 312. Why was this? One line, simple. As it was not common to the union and state, inasmuch as a UT was not a state. Well, joint cadre means it has to be government of India and a state,
The state.
or two states. Now, Himachal is not a state, therefore out you go of both the categories. That's a simple argument. Now let's come to 7. I think it's always changing. Now your lordship will come straight away to para 7, where they compare the provisions, and then come to 8.
Yep.
8 is enough.
58.
It's been read, marked by your lordships, but just note, directly the contention reversed is as follows. 7th line before the end of the paragraph. The High Court was therefore wrong in taking a contrary view and in holding that UTs are not states for purpose of 312 and the preamble. All that Mr. Jain is saying is that contextually, UTs are states for 312, UTs are not states for 309. That your lordship decide. Any great article in the Constitution so suggests? Is the subject of 309 Arctic Pole and the subject of 312 Arctic? Is the subject of 309 directly opposite to the subject of 312? Imagine the difficulties that arise if UTs are states for 312, UTs are not states for 309.
What do you have to say about the legislative history argument on part 14 with the
Well,
SCR?
it's completely unnecessary. Completely unnecessary. Legislative history, Malas, has been
Text, basically.
legislative history has been legislative history is completely, it's very good to have all these long submissions with all the details. Very useful to have them, but they have no relevance to the case for the two simple reasons. It is superimposed by 239 AA in 92. It is superimposed by a Lordship's General Constitution Bench, and it is interpreted by Prem Kumar Jain, which doesn't find a mention in this legislative history. So, Malas, yes, it arose historically because your Lordship knows we had 4 categories of states. We knew we had Raj Pramukhs. That's all very valuable, but it doesn't address the issue. That is, it would have been relevant pre-Prem Kumar Jain. That look, it's a grey area. It's a tabula rasa. Your Lordship has not yet painted on it and decided that UTs under Part 14 are states. Post Prem Kumar Jain, where is the relevance of any history? Because your Lordships were called in only for that reason. Your Lordship had a fight only for that reason before the High Court, which your Lordship resolved. After that, Malas, whatever Part 3 state was, we know Malas, Ajmer and these other states and all that, but what is the point of all that? Now, Malas, kindly come to some very interesting rules which are not shown to your Lordship. Malas, your Lordship has shown transaction of business rules for almost 1 hour. Kindly see if any of it is remotely relevant after your Lordship sees 4 rules. I am now, Malas, in para 3 of my submissions. Whereas transaction business rule only says, generally, what is mine, it is divided like this. What is mine is the operative word. It doesn't say that if I divide it like this, you get what is not yours. But
Now,
just bear with
now, Dr. Singhvi, we got your submission. Now, insofar as the All India services are concerned,
that is the rules now coming up.
right, we'd like you to address us.
Straight away, straight away. It's about 4 or 5 rules, and in fact, not even 4, 3 rules and 3 paras of final.
Yes, sir.
These are need to show to your Lordship. Your Lordship has seen it. It will take 2 minutes to show it. May I read it? May I read it first?
Para?
Allocate para English 3 months, ordinary 3.
Yes, let's read that.
Allocation of all India services civil servants in respect of Agmut cadre is done by the Joint Cadre Authority and not the Ministry of Home Affairs. Directly shown to your Lordship's Ministry of Home Affairs. That's wrong. It is the Act will apply, then a rule under the Act, then a notification under the rule, or a resolution shown to your Lordship. The resolution is shown for a very different purpose. What your Lordship is told is under a resolution, MHA looks into it. That was a temporary arrangement. Then there were rules, first Act, Section 3, then Rules 4, and then a notification of 25th April 1995. And it's clear that UT is the state. And one more point before I read it. In all these joint cadres, the whole idea, what is the meaning of joint cadre? My reps exist and act and decide as much as their reps. My chief secretary sits there, Malas. Joint cadre is, Malas, collegiate. It doesn't mean he's excluded, but equally doesn't mean I'm excluded. Now let's kindly come. The Joint Cadre Authority is established under Rule 4, take out the reference, of the All India's Joint Cadre Rules of 1972, which are statutory under 3.1. Now the order is the reverse. 3.1 comes first, then comes Rule 4. Section is 3.1, Rule is 4. The authority is a committee comprising representatives of each of the government of states, constituting the Joint Cadre. The Agmut Joint Cadre has been established under this rule by notification dated 25/4/95, that's the third one. Act, rule and notification. Whereby Delhi, along with Arunachal, Goa, Mizoram, is represented in the Joint Cadre Authority through its chief secretary, whereas the other union territories are collectively represented by the MHA. This distinction itself is important. Delhi has a chief secretary sitting there. MHA acts for a few other smaller UTs or whatever your Lordship will call them. The function of the Joint Cadre Authority under the All India Rules of 72, the fourth point was, under Rule 5.1, quote, to determine the names of the members of the All India services who may be required to serve from time to time in connection with affairs of each of the constituent states and the period or periods for which their services shall be available to that government. Just pause here, brothers. Look at the bizarre result which is being canvassed before your Lordship. Even at the time of allocation, your Lordship knows civil services. I am an officer, brothers, of the central service, or IAS. Cadre is, let's say, brothers, whatever, UP. Today, brothers, from Delhi, some ministry, I am to be posted. At that time itself, a joint cadre will operate for a UT. Where I am sitting, he is also sitting. Look at the bizarre consequence that after I am posted, even at the time of posting, the chief secretary has a say. But after I am posted, the state of NCT cannot decide whether to post with Mr. Farasat, to post with Mr. Rahul Mehra, post with Mr. Chadda, or to interchange them every 6 years according to whatever, 6 months according to whatever they want. This I am showing given at inception. Now see those rules. First turn to section 3.1. Bookmark 45, page 3949. Well, with respect, this is actually driving a coach and four through a very well-established harmonious scheme. It's only a question of requiring a Lordship's interpretation. Imprimatur, not even interpretation.
3949.
Yes, 3949, bookmark 45. Show me now. Your Lordship saw this briefly, but in view of my learned friend's argument, it's very important to see it. In this, Your Lordship will see, I think rule 4 and 5 is enough. Why does it not go up and down? Do you not scroll? You scroll it for me.
Yes.
Wait, let me do. Does my lord have it, please? 3949, All India Services, bracket, Joint Cadre Rules of 1972.
Yes.
See, I want to show 3.1 of the Act. You are not showing 3.1 of the Act.
Yes.
May I just read 3949 on the top? Has my lords got it?
Yes.
The title is All India Services Joint Cadre Rules of 1972. It is not disputed that things like AGMAT, etc. are joint cadres. It's not even disputed. In exercise of the powers conferred by 3.1, this comes at the top. Lordship will note 3.1. It's in the file. I'll give you also the page also. It doesn't have to be read. Act.
Bookmark 9.
The central government, after consultation with the governments of the states concerned, hereby makes the following rules. Well, just mark that section is under the All India Services Act of 1951. It is at page
820.
820,
Bookmark 9.
bookmark 9. That section 3.1 is 820, bookmark 9.
Yes, below one tomorrow. Dr. Singhvi, we don't want to rush you. Are you going to finish today or you will spill over a bit tomorrow?
I mean, I don't want to ask your Lordship to sit so late. Give me 1 hour tomorrow, I'll finish it off. First, your Lordship will assemble here and finish it 1 hour, then your Lordship will take your normal.
1 hour more you want?
Well,
He said
I don't want to
90
just,
minutes.
Mr. That's very unfair coming from him.
No,
No, not at all.
No,
This
that's
is
a very,
matter of-
I can understand him.
Dr. Singhvi,
My
it's a
learned
matter
friend
of-
argued
we
for
don't
my
want to-
entire
like a civil
150
appeal or a
minutes.
criminal
His
appeal
60
where
minutes
we
became
can stop
150
it
minutes.
And read it on us.
I am taking into account 150 minutes of argument.
Alright, that's why I asked
in
you
1
that.
hour tomorrow. I'll do it even in 45 minutes tomorrow, first thing in the morning. Constitution bench, well, I mean, I have a problem with it. I can't help it. My learned
SIB.
Dr. Singhvi will time tomorrow.
I'm very deeply obliged.
Keep it first on board.
The Lordship will assemble first.
One clarification.
And then our regular boards will start.
I'm very deeply obliged.
Only one,
Very deeply obliged.
one clarification. By today's submission, may be read in conjunction with the earlier. It's not
Yes, yes.
substitute.
No, obviously, so it's a supplementary.
Supplementary.
We also thought that, Dr. Singhvi, you've made your point. We can also reflect on it. If we have some queries, we can pose you. Otherwise, we will not have the opportunity of posing.
Certainly, Mr. Certainly.
Can
I
also-
may even take lesser than 1 hour.
We can also now sort of
Dear Lord,
reflect on what has been argued and
Deeply
then-
obliged.
But would my lords be assembling at 10:30?
Yes, yes.
Yeah, we'll take it up at 10:30 only, right? 10:30, want to do it again?
Otherwise, other benches will be impacted.
So we'll keep this matter between 10:30 and 11:30. Then we'll take our mentionings so that my learned brothers and sisters are free for their regular work. And then we'll start with our regular work tomorrow.
Obliged, very, very deeply obliged.
Please,
Brother Narasimha and I will come back for the mentioning in just now.
grateful to you.
1 hour, no? 1 hour.
1 hour.
I will not exceed a minute. Lordship may time me. I'm not going to exceed. Certainly.